I don't have anything to...
Here, let's just clink it against your watch.
Yeah, clink it against the watch.
There you go.
Good to go.
Oh, I so don't want to do that on a crystal watch.
Oh, no.
All right, so we're going to talk about something today because somebody asked us to.
Yeah, so
imagine.
Sunday, when our most recent podcast dropped on whatever,
It's so
on
cool
YouTube.
when you say drop. That's so like...
Yeah, so like...
It's like so 2025.
Be there when it drops.
Yeah.
I had
So
no
there's,
idea what that
there's a
meant.
live feed with commentary and stuff. So we got into a discussion in the commentary, I think slightly unrelated to the content,
Of course.
about the UK's right to silence versus the right to silence in Canada. And there is, a significant difference. And so they asked if we could, a bunch of people then said if we could review sort of the right to silence, your right to counsel, and some of those concepts. So this might be a bit dry because it's like going to law school in the first year.
It's
and
first year crim.
taking criminal law and maybe charter
But this
rights.
ties in as well, like, as we've said a number of times, it's just like, keep your mouth shut. Like when you're being questioned by the police, they're not your friend and they'll try to present themselves as your friend. Yeah. But, and the phone call in Canada that you get to counsel is really generic.
But just talk about for a moment before we get it. There's this psychological urge for people when they are detained and arrested and brought in to want to cooperate.
Of course.
Right? Yeah. And we've seen that
Time and time again.
Diana, there's been some instances and it's...
Well, and quite often they're told too is, hey, we know there's two sides to every story. We want to hear your side. And
right.
so it comes across like they're trying to be helpful. But in reality, primarily, the job of the police investigating an allegation is to lay charges and to lay as many charges as possible. And so, and unfortunately, when people are asked, for their side of the story, they're not fully aware of what they're accused of. So it's difficult.
Not even close.
Yeah. It's difficult to actually answer, tell your side of the story to which you're not really sure what you're responding to.
And I think to be fair, we've seen instances where the police, because we deal with sexual and domestic related cases most frequently, the police are quite happy to take a statement. But I've seen police officers say, you don't really have to talk to us. It'd be better if you didn't.
Yeah, I've seen that.
Yeah.
And then people still insist on talking.
But.
Yeah, and the officer's going, really, now's not the time. Yeah. And it's kind of funny, but there is this psychological component to it. But then, the desire to elicit a confession becomes much more heightened in the gravity of a case. So if it's a very serious sexual assault case, or a series of sexual assaults, the police will have that much more of a heightened interest in obtaining a confession, or in a murder case in particular, where you see a lot of the litigation come out in murder cases where sometimes, depending upon the evidence you have, a confession can be exceptionally pivotal, and we'll talk about that a little bit here. So let's just talk about this, and I'm gonna drone on for a few minutes, and then
where we're kind of coming from is like there's a lot that the police are permitted to do in an interrogation, and then there's certain lines that can be crossed in which the statement that's obtained is not deemed admissible in court.
It's not voluntary.
If it's not voluntary because of a certain number of reasons. So that's kind of where we're headed, is where is that line?
And one thing I want to say is, again, people complain about our charter rights. Our right to silence, very similar to the United States, is fairly sacrosanct, unlike the UK, which I find disturbing. And let's talk about it. So first of all, the right to silence is enshrined in our Charter of Rights and Freedoms in Section 7. So it's a fundamental constitutional right under Section 7 for persons to have the ability to not answer. There's no requirement to answer questions from police or other authorities when you are approached by police or detained and arrested by police. And a crucial aspect of this principle is part of our innocent until proven guilty concept, and it's to protect people from self-incrimination. So they're all tightly connected. The exercise of the right to not make a statement or to not subject yourself to answering questions will not draw a negative inference at a trial proceeding. And I just want to say this at the outset because I know people were interested in that, and I'm going to expand on that a little bit later. So you have a fundamental right in Canada to not answer questions of police. And there have been a little bit of debate over the last several years that, let's say you're approached by police when you're walking on the street and they want to talk to you. Do you have to answer their questions, provide identity or other information? You don't.
There's a few exceptions. If you're operating a vehicle, for example,
Good point.
If you're a bicyclist and they stop you, I've seen bicyclists in my neighborhood run stop signs. If you get pulled over, you have
don't
to.
Get me started.
I know.
I have a devil's advocate question.
Just hold on.
You have to
I just wanna mention
identify
that I
yourself in that type of scenario.
So in certain scenarios, you do have to provide your name, some identification, address possibly, but nothing really
nothing incriminating.
beyond that, nothing incriminating. But in instances where we used to have these police stop various individuals on the streets, they referred to it as carting back then.
Yeah, I remember that.
That's not a practice because
Right.
it was discriminatory in nature. That's the police are able to utilize now. And more importantly, if you're stopped for no apparent reason, you don't have to cooperate.
Yeah, and carting meant, hi, I want the following information for you. They literally had
A card. Because they knew people they were stopping, or at least they had information
known
on
drug areas or stuff like that.
gang-related activity.
So
etc.
my question is, as you mentioned, you have a right against self-incrimination. So a lot of the general public would say, well, if you're guilty of something, why would you have a right to not incriminate yourself? What does that mean, the right to not incriminate,
The burden remains on the state always to prove.
Yeah, so it's, again, this is why I started off this way. It's a hallmark of our democratic process that people are innocent until proven guilty beyond a reasonable doubt. So we have the presumption of innocence. Tied up within that presumption of innocence is the right to remain silent, not to be co-opted
Against yourself.
into cooperating with the police or other government authority to answer any type of questioning.
Right. So that's kind of my understanding too, is that it's important for people to understand that, the state has vast resources and you can't be coerced or forced into participating and helping them to prosecute you.
Or legally mandated to do that. And as we will talk about, the police, even though you assert your right to silence, and then we'll talk about under Section 10B of the Charter, you have a right to counsel, and we'll expand on that later. That doesn't mean that the police stop interviewing you, and we'll get into the intricacies about that. But the police can ask you questions even though you want to remain silent. Be brought into the police station, get your right to counsel. You can call a lawyer, get your advice, and then they can put you back into an interview room, and then they continue to ask you questions. And let me just say this, police tactics can consist of deceit and certain trickery within permissible bounds, but you're not going to be given the information necessary to make an informed decision about whether you should be answering these questions, because information is power. You won't be told necessarily the truthfulness of the allegations.
There's no evidence sharing at that stage.
And therefore, the way in which you answer a question can incriminate you, even without intentionally doing so. That's why it's extremely important to remain silent.
I would also add that when people are arrested, when they're first arrested, they're quite often in a state of shock, and there's a lot of fear. The authority of the police being publicly arrested, things like that can contribute to a state of mind. And, you can be held in detention for a number of hours before they even start asking you questions. And so all of that stress can result in people not being in their right state of mind when they start talking.
And wanting to make
Particularly
things go away,
when you're dealing with people who have never been accused of anything in their life. The arrest procedure is extremely traumatizing to them. And they are not in their best situation, psychologically, emotionally, or otherwise, to really embark on trying to defend themselves to really an allegation that has only bare bones information they're provided to. It's extremely, and you're right, so they could be brought into the police station, get their right to counsel, sit in a cell for an hour or two, then be brought into an interview room. It depends on the circumstances. Police in general, in some cases, are very quick to process, but in others, if they want to interview, you're not. So not ideal circumstances. Now, as I said, under the Charter 10B, you have a right to counsel. And just, let's say this, if you do choose to speak to the police to answer questions, better not lie, because that can come back and haunt you badly or could lead to further charges.
That's right.
So if you are going to answer questions, you're best to try and do it truthfully.
But why would you?
Again, our advice is always to remain silent.
Right.
There are certain limits to the right to silence. There are some circumstances where there are statutorily compelled statements, the Insurance Act and certain others. And so there are certain instances where there is
a positive duty.
A positive duty to answer questions, but those are generally in other areas that won't affect the type of criminal cases that we talk about on this podcast, or most of you would be concerned about. And I just want to say this about the UK, and then I'll shift over to you for a moment. So in the UK, there is the right to silence, which is enshrined in case law and, I guess, statute. And it allows individuals to refuse to answer questions during a police interrogation or while under arrest. In addition, in the UK, you're allowed to have a criminal solicitor present for an interrogation with police. In Canada, you will not be allowed to have a criminal lawyer in an interview room with you. There isn't specifically, as far as I know, a case saying thou shalt not have a lawyer during an interview.
No.
But it will never happen.
Right.
It will not be allowed. But in the UK, you can have a solicitor present, and majority of the time, that is really something you should have. But the right to remain silent can be used against you in court, particularly if you later try to use information that you withheld during the interrogation process.
You're talking about the UK or Canada?
UK. So that was one of the points that we were talking about on the question and answer feed. And that really puts an individual who's accused of an offense in the UK behind the 8 ball. Because they may choose for very good reasons not to answer questions, and if they testify at trial and those areas are pertinent, they can be cross-examined on their right to silence, and a court can draw a negative inference against their credibility because of that. So whether you're being tried by a judge alone in the UK or a jury, there can be an instruction to a jury to draw a negative inference for you withholding that information.
That's bad.
I think it's very damaging.
Yeah.
I think that really undercuts your right to remain silent.
Well, it makes you ask, what do you mean by right? If exercising the right can be held against you, then it's not really a right then, is it?
I agree with you 100%. Mm-hmm. I take the position
it's a liability.
that yeah. And it's even worse because you're allowed to have a solicitor there. Like, sure, you can stop during an interview in the UK and talk to your lawyer in private. You're in such a disadvantage in these circumstances, particularly when it's a very serious offense and there may be a lot of evidence. I agree with you. I think it's in word only a right to remain silent. So that is a very big distinction between Canada and the UK and the United States, because their system with respect to right to remain silent is very similar to ours in certain ways. And that's why I say we're very fortunate to have the rights that we do here, even though they are fundamental rights and not absolute rights. Now, when you're arrested, you're given your rights to counsel. I'm going to flip it over to you, but you also get a caution.
Yes.
Okay? And a caution advises you that any evidence you can provide will be used against you, blah, blah, blah. And then if at a trial you gave a statement, it's the obligation of the prosecution to establish that the statement was voluntary. In other words, any type of statement to police is not admissible so if you contest its voluntariness, it's not admissible unless the Crown can establish beyond a reasonable doubt that it's a voluntary statement.
And that onus is always on the Crown.
It's always on the Crown. So
That phrase voluntary, sounds like in common language that, well, if you speak, it's voluntary, right? It's not like somebody's forced you to speak.
So let me talk about this for a moment. But there are different
things that can negate it.
And then I'm going to pass the buck, okay?
Okay.
So, or the 50 cents, whatever it is, because we have such high taxes in Canada. So voluntariness means a statement must be made voluntarily without coercion or undue influence. So there can't be any form of threats or promises or inducement to give that statement. Importantly also, the individual who gives the statement has to have an operating mind. And that's a term that basically says the person making the statement must have been in a state where they could make a rational decision, not impaired by certain factors like mental illness or extreme intoxication. Also, to be voluntary, there needs to be free of oppressive circumstances, although, as we'll get into, certain oppressive circumstances can exist and will not negate the voluntariness of a statement. But it can't be obtained under conditions that are so oppressive that it undermines the free and voluntary nature of the statement. And there's also some unacceptable practices, such as trickery and deception. But there is a fair amount of latitude given to police to misinform and to use certain deception. And frankly, there's interesting cases where you have a person who's detained in a jail, who's charged with a homicide, and they'll plant an undercover officer who will pretend to be another inmate, start to talk about his situation versus yours, and then try and obtain a confession. So there's lots of leeway and
trickery
that's allowed. And so, that sort of encapsulates that. So talk about for a moment, Michael, 10B. What 10B means.
Right. In Canada.
In Canada. I'll keep it simple.
Because they don't have 10B in the UK.
That's right. So in Canada, we have the right to counsel on detention or arrest, both scenarios. And basically it reads, everyone has the right on arrest or detention to retain and instruct counsel without delay and to be informed of that right. Very short sentence, but a lot of litigation has gone on, especially at the Supreme Court of Canada.
Tons of litigation.
To parse each word and explain what it means. I'll get to some of that. But basically, there's three components when 10B is invoked by someone who's arrested or detained. Firstly, the officer must inform the detainee.
Can I just ask a question? Yes. Does a detention only mean physical or can be psychological?
Can be psychological.
Okay, go ahead.
Good question. A+. The officer must inform the detainee of his right to instruct counsel without delay and of the existence and availability of legal aid and duty counsel. So part 1. Part 2, if the detainee has indicated a desire to exercise this right, the officer must provide the detainee with a reasonable opportunity to exercise that right, except in urgent and dangerous circumstances. And finally, Part 3, which is the hold-off clause, that we call it that, the officer must refrain from eliciting evidence from the detainee until he has had the reasonable opportunity to contact counsel, except in urgent and dangerous circumstances. So, in a nutshell, those are the obligations that are imposed on the police when they're reading that caution we see on TV all the time.
So there's an informational component, which is advising of your rights, and then an implementational component. Right. Sorry, my throat's a little dry.
That's okay.
If you decide to say, I'd like to speak to a lawyer. Now, we could be here for literally days if we wanted to talk about all the relevant case law and all the nuances of this, so we're not doing that.
Right. But we'll talk about a few of the interesting points that people ask us often. So, what does without delay mean? People often ask me that question. Basically, the courts have ruled that without delay must be read with a purpose of understanding of the charter position. Bottom line, the cases have come out with the police are obliged to comply with 10B immediately. It's not in an hour, it's not in 10 minutes, it's immediately upon arrest or detention, subject to officer safety or other necessary limitations. And so the courts have said immediately has to be read in practical terms.
Right. Well, let's say you're in the middle of a search, right? The police have entered your house, you're detained.
That's the example I was going to ask about.
They give you a right to counsel. At that point, they'll say, okay, thank you, we're going to get you that opportunity. But they're allowed to conduct their search.
Right.
And they can take you to the station before connecting you?
Yeah, but in certain circumstances, you can imagine where you can argue that because we have cell phones or smartphones, that once the evidence has been secured and the search is completed, if there's some delay in transport, you'd have a right to maybe contact counsel. But it's not ideal because you're not going to be having a private moment. So
the types of short delays that have been permissible are officer safety, doing a pat down to make sure there's no weapons after you've been arrested, a quick lookup on the in-car computer, checking license plates, seeing if there's any warrants out for the person, searching detainee's personal effects, or calming the detainee down if he's out of control, if he's having a mental health crisis. So in those types of situations, some delay is okay. But here are examples where the courts have said, no. This doesn't count. So speaking to the detainee's passengers, if it's a car stop roadside, completing officer's notes, arranging for a tow truck, typically in impaired cases.
A lot of this has come out of it.
Over 80
litigation
cases
has come out of impaired related cases.
Counting seized money, securing open liquor, consulting a fellow officer about the identity of the detainee. Those are not acceptable delays. The courts have ruled in those various sorts of cases. So you asked about executing a search warrant. In that case, they're busy executing the search warrant, but they still have to give you the right, and then you have to have the opportunity to implement that right as soon as
presumably,
possible.
while they're searching the house, they're not asking you questions at the same time. So
the minute in circumstances like that, there's no way for you to meaningfully exercise your right to counsel. Right. So they got to hold off in questioning you.
But it was more important when they start asking you questions. So if they're searching your house and not demanding answers from you or interrogating you in any way,
trust me, sometimes they do. They'll go, "Tell us the room where the gun is,"
right.
Like, or where the drugs are.
Yeah.
Well, our courts have ruled that executing a search warrant, they're not permitted to use that as an excuse. I've had clients call me during searches, so.
Me too.
Yeah.
Police have properly done where a person can be secured safely,
right,
and get a right to privacy. We've had it happen where we've been called during a search.
Right. And waiver of the right to counsel also has a high threshold. Very high threshold. It has to be equivocal, not unequivocal. Equivocal answers.
Officer, what do you think? Should I call a lawyer?
Yeah.
Well, I can't give you that advice, but I don't know what I should do. I've never been in this circumstance before. What do you think, officer? I think you should call a fucking lawyer.
Yeah.
Do you have a right to counsel of choice?
Okay, so that's a good point. As far as I'm concerned, no.
No, you don't.
Okay, so I had a case in the Court of Appeal, trade chef, a long time ago, and I literally got angry at the Court of Appeal and said, so just call it the right to duty counsel.
Yeah.
So now there's been a pendulum switch. So when you're detained, you have a right to call, say you happen to have a lawyer that you want to call, you have a right to call that lawyer. But you have to be duly diligent in exercising your right. So if you say you want to call Mr. Burry and it's 3 o'clock in the morning and he's long asleep after having a glass of wine and walking his Frenchie, I'm just saying one, and walking his Frenchie for like 3 hours in the evening, you're not going to get in touch with Mr. Burry necessarily. So they'll give you some opportunity to contact Mr. Burry, and then they should say to you, okay, is there another lawyer you'd like to call? Well, okay, I'd like to call X. And you might get a chance to do that. They could give you the listing of lawyers on the computer system now to make a counsel of choice, but there is a limit to this. Right. And then they will say to you, well, you can call duty counsel at this 1-800 number, and you'll get immediate advice right away. So there are limits to your ability to get counsel of choice. And with respect, even though the case law has changed a little bit in that regard, it's not as respected as I think it should be. But I understand that they need to conduct their investigation and continue.
It's not an unlimited right. There's some...
And duty
fair enough,
counsel...
somebody could just say, like, the most high-profile defense lawyer they can think of, even if they've never spoken to the person before, and then try and put off an interrogation.
It's like on an impaired driving. Right. It's 4:43 in the morning. I want to speak to, Eddie Greenspan, who has passed away and was, one of Canada's most well-known lawyers, and you're not going to get Eddie at 4 o'clock in the morning,
you're
right?
Not.
So there are absolute limits to that.
You can't use it as a tactic to evade,
especially in impaired cases, because the idea was you need to get the readings within a certain period of time, and the police officers know why you're stalling. Right. But it's not just simply impaired related cases. There's other cases too. But there are significant limits on your right to counsel of choice. Right. And the reality is duty counsel is available 24/7, and they provide, focused advice and access to at least, sound legal advice at the time that you need it.
Right. So just to kind of tie things off, what does amount to a waiver? So in one case where the accused said, no, I have no use to call one, that was considered a waiver. Or, no, I'll talk to one tomorrow. Yeah. That was considered a waiver. So the police, they did what they were supposed to do. The person made an informed decision.
And let's take this to practical terms, because we've seen this countless times. I mean, in our early years, of course, we've all defended, impaired related cases.
80s,
which has really been the crucible of the formation of the right to counsel law. And officers will say, are you sure?
Right.
Sometimes they do that. And then they also want to, if there's a language barrier.
I was just going to mention the language problem.
Well, that's a whole different...
Yeah, it's a whole different area, but, they've gotten better in that where, you try and get access to, an interpreter to assist or to get a police officer who can speak the language that you have to communicate your right to counsel in the language that is your first language. So it's been better that way. But...
do you remember the Prosper warning, by the way?
Yeah. Tell me about.
It's an interesting little twist. So
Regina versus Prosper.
Yeah, it's a Supreme Court of Canada case, 1994, 𝐿 65.
1 year after I started practice.
Wow, all the good cases were back then.
𝐕𝐈𝐃𝐄 reminds me she was still in diapers.
She tells me the same thing.
One of her associates.
Yeah, where an accused is detained and asserts the right to counsel in a diligent manner, and then changes their mind, the police must administer a Prosper warning. Prosper was the name of the appellant in the Supreme Court of Canada case. This warning requires the officer to tell the detainee that he still has a right to a reasonable opportunity to contact a lawyer, and that during this time, the police cannot take any statements until he had a reasonable opportunity to contact a lawyer. If the officer fails to give the Prosper warning, there will be a charter violation. So interesting.
Yeah, and that's important because you can imagine somebody who's under the stress, tries to call a lawyer, can't reach them. They might go, okay, forget it. Go ahead.
Yeah.
Just ask me questions. They just want to get it over with.
Right.
And that's why the Prosper warning is important.
Right.
Let's just say one other thing. If you have a violation of the right to counsel, so let's give a scenario that the police say, do you want to speak to a lawyer? You say, yeah, I'd like to speak to Mr. Burry. Okay, here's a phone, call him. They come back in 20 seconds later. They go, you didn't get Mr. Burry? Okay, good. You're on the line with duty counsel right now. Duty counsel will speak with you. You get to speak with duty counsel for 4 minutes, and then they put you into an interview room, and then you confess. You may have a violation there of your right to counsel because they did not give you sufficient time to implement your ability to get in touch with Mr. Burry. Because you could use maybe he used a cell phone number or an office phone number. Maybe he could have sent an email. So you could have a breach of the right to counsel, right?
Yeah.
But
counsel of choice.
Well, let's just say the right to counsel. Okay, it's just easier that way.
Right.
But then, when you find a violation under our analysis, then you have to determine whether the evidence is admissible that they have obtained. Generally, in confessions, it gets excluded.
Right.
But there is an analysis you do under Section 24 of the Charter to determine whether the evidence should be admitted or not. So, typically in the past, it's been about the breath readings themselves or a blood sample. Or in more serious cases, it could be not just a confession, but the location of a weapon or the drugs or something of that nature.
Right.
So there's all this calculus that goes in under 24.2 to do the determination as to whether, in spite of the violation, would the admission of the evidence in and of itself bring the administration of justice into disrepute.
Right.
I do not want to get into that because that'll be 2 weeks that we'll be here doing the podcast. I just want to give this information.
So we mostly covered stuff that's like before they start talking.
Right.
But then there are issues that can negate the content of any statement made if certain techniques are employed in order to coerce statements, or if the person's subjected to unusual conditions, things that put them in not a right state of
Vulnerable
position. So, aside from just when you begin talking, there's a number of factors that have been discussed in case law.
Good segue.
That can undermine the voluntariness. Even if they have it voluntary at the beginning, that voluntariness can be undermined by conditions they're subjected to.
And good segue. And this is where the podcast becomes interesting, okay?
Yes.
So again, it's important to understand that the police can use a certain level of trickery, deception, and can ask you questions for hours, even though you're saying, thank you, officer, I'm not going to answer your questions. Thank you, officer, I'm not going to answer your questions. Thank you, officer, I'm not going to answer your questions. Let me just say one thing. If you are giving a statement, and during the course of your statement you say, I'd like to speak with counsel again, you should be permitted to speak to a lawyer, but you can't stop every 15 minutes and ask to speak to a lawyer. They'll do that once or twice for you, but that'll be the end of it. But let's say you're in an interview room, and you maybe have had a chance briefly to speak to duty counsel, and they've got you in there. What is too much? And this is where it gets interesting, because there's a really great case out of the Court of Appeal.
The recent one.
Yeah, and there have been so many cases over decades about this, and even though trickery and some oppressive circumstances are allowed, this is a very interesting case, and it involves a homicide, of course.
Of course, yeah.
And so I'm going to give it to you, Michael, to start. You can give the name and the citation of the case.
So this is a recent Ontario Court of Appeal case. It's His Majesty the King and Justine Ordonio, Ordonio, and the site for that is 2025 ONCA 135. And as Joe said, this was basically a murder trial. In early 2019, Mr. Ordonio was tried before a judge and jury and convicted on one count of first-degree murder for his involvement in the stabbing of Teresa. I think that's pronounced Hissin. In any event, the complainant or the dead person.
That would be a victim.
That would be a victim.
That's the only time
you'll use the word victim.
Yeah.
I just think it all.
Yeah, she was murdered in 2015.
They're actively dead, so
she's pretty much a victim of somebody. So she was found dead in the driver's seat of her BMW in a nearby Scotiabank parking in Mississauga. She had been stabbed to death. The Crown's theory was that the stabbing had taken place a few days before then. So 3 persons were charged. Mr. Ordonio, her son, and another co-accused. So central to this whole case was the Crown's case was a statement given by Mr. Ordonio during, get this, a 13-hour interview on November 10th and 11th.
Yeah, so this was a confession that was absolutely crucial, and Peel Police knew they needed a confession, frankly, and were extremely desirous of getting one, and it was a cornerstone of the prosecution.
The Crown conceded on the appeal that without this statement, there was insufficient evidence remaining to proceed against the accused in this case. Where to begin, huh?
This episode is sponsored by EasyDNS. EasyDNS is a domain name, registrar, and host that has a 30-year track record in the domain and web hosting industry. Whether it be cancel culture, platform attacks, or nefarious actors online, move your domain and web hosting over to EasyDNS, one of the most secure web hosting services, and help support Not on Record in the process. All you have to do is go to easydns.com/notonrecord, or when you sign up at EasyDNS, use the promo code NOTONRECORD at checkout. Thank you, EasyDNS, for your support of Not on Record, and now back to our podcast. Thank you.
Well, let me give a sort of summary. So he was interrogated, as you noted, for 13 hours while falling in and out of sleep, confined to a cold room, not given food until 6 hours after his arrest. I think he did get Swiss chalet, which is better than
quarter chicken white.
Yeah. Well, it's better than McDonald's.
It is.
And he was subjected to aggressive police questioning about his suspected involvement in the murder, including the use by the police of the Reed interrogation technique, which we'll talk about a little bit. It's a coercive method of interrogation from the United States that was developed in the 1940s with the end goal of getting a suspect to make incriminating statements. But of course, it's premised on, of course, that your suspect, for the most part, is guilty. But there are 3 stages to it. We'll go through it later. But so this was 13 hours in and out of sleep, confined to a cold room, not given food until about 13 hours later. And if I'm correct as well, I think the Crown conceded on appeal that there was a 10B violation.
Oh, yeah.
So on appeal, the Crown conceded that by failing to hold off questioning, because I think what happened was he was arrested, and when he was put into the vehicle on his way to Peel, he was arrested in Toronto. He was cautioned and given his right to counsel, but he was then asked whether the police had made a mistake by arresting him.
Right, so they didn't do the classic hold off.
Did we make a mistake arresting you?
The appellant denied any response.
I didn't f***ing do it.
Okay, so that's so he denied any responsibility for the crime and responded to some other questions posed by the arresting officers during the drive. The Crown conceded on the appeal that by failing to hold off questioning until the appellant had spoken to counsel, the police had breached the appellant's rights under 10B of the Charter of Rights and Freedoms.
Oh, this is where it gets better.
Yeah, so this is an appeal. And by the way, James Lockyer and Jeffrey Krause were for the appellant. There was a number of people involved, including Frank Addario, and Jocelyn Rimple on behalf of the Criminal Lawyers Association. So this was an important case, you know, and I think this highlights some of the real issues we have with continuing with confessions, and we have to be mindful. I just want to say this. There is an absolute psychological component to people who are in highly oppressive circumstances where they falsely confess just simply to get out of the situation. And after a while being told you're guilty, you're guilty, you're guilty, it's amazing how with certain techniques used by skilled officers in oppressive circumstances, someone can actually come to believe maybe I've done something because they are so tired, so exhausted, hungry, that they wind up giving a false confession. In this case, what was interesting is the confession was on certain points that did not specifically align with the Crown's theory in the case.
I'll confess to anything.
And just to follow up with what you were saying too, I mean, it shouldn't be that surprising, although people still are surprised, that people do give false confessions. And it's been brought to light by Innocence Project. There's been a number of high-profile cases in which people were convicted on their confessions and then later found to be innocent. And we know what happens. And so what we're talking about is why it happened.
So, you know, the Innocence Project and then AIDWIC with James Lockyer and that excellent group of criminal lawyers who've worked tirelessly over the years to deal with, you know, wrongful convictions who are based on, you know, faulty biological evidence as well as false confessions. There is tons of litigation about false confessions, and it is absolutely a legitimate psychological phenomenon that people will falsely confess given oppressive circumstances, and sometimes not even that oppressive. There can be all sorts of factors why it happens. It just happens. You know, humans are humans, but you can imagine in circumstances like this, and in some instances where interrogations have gone over the course of a day or longer.
Well, this
and
was
we've
pushing
previously discussed cases too, like in terms of what we mentioned earlier, where people have asserted that they don't want to answer questions 17 times, and they continued to ask questions, and that was found to be reasonable.
It's permitted.
It's still permitted. Like, so just asserting your desire to be silent doesn't mean that your rights are being violated. But we're getting into the techniques that do violate the rights.
That's right. But that's an important point, because we've said this before. Police can still ask questions, and it can go on for hours. And that's why it takes a lot for an unsophisticated accused to be able to say, "Thank you, officer, I'm not answering any questions. Thank you, officer, I'm not answering any questions," and be able to sit there over and over and over, because they'll be using techniques to try and get you to talk. They'll be using, try and relate to you, try and develop a rapport.
Ask about your personal
try and
life.
assess
It's
you.
not to do with the accusations. Get you talking
Get
about
you
that.
talking.
And then,
It's very, very hard. And police are skilled at this. And as I've said when we started this podcast, the more serious, the higher the gravity of the offense in question and facts, the more the police will have a heightened interest to try and obtain a statement from the accused. So, 13-hour interview.
Yeah, well, but do the timeline so people can appreciate how.
Go ahead.
So he arrives at the police station at 1:17 p.m. Okay. He's taken directly into an interview room. At 1:35 p.m., the detective who was interviewing him enters the room and just starts talking with him. He makes a telephone available to him. The accused speaks with a lawyer for under 10 minutes. Conversation ends at 2:13. Remember, they arrived at 1:17. Then the detective re-enters the room and begins to question him. The interview continued until approximately 2 a.m. the following morning.
November 11, 2015.
November 11th. That's a long stretch.
There were some breaks.
non-stop, right?
Yeah.
No. There were some breaks for water, cigarettes for the appellant, bathroom breaks, swish chalet, and some periods where the detective simply left the room.
Which is in and of itself
A technique.
a technique.
Because you have the camera still rolling. Right? So an accused is still on video, may forget they're on video, and may start talking to themselves, or will exhibit certain behaviors that will then lead the officers to think, aha, we're on the right track.
I've actually had that happen. I've had an accused talking to himself. I've had an accused say, "Why did I do this?"
That's right.
Then there was the Jodi Arias case down in the States where she did a headstand.
Let's do this objectively,
Yes.
because look, because we're defense lawyers doesn't mean that people who are truly who have truly committed the offenses should not be brought to justice. I mean, the reality is crime is serious, and the more violent the crime, the more serious, and it's an impact to society. But you will see instances when the police leave the room and they're using that technique on purpose, and then somebody does this, and they're going,
that move.
I can't f***ing believe this has happened to me. I shouldn't have done this. What did I get myself into? Right. And we've all seen that.
Oh, yeah.
Our primary goal is to make sure that people don't end up giving false confessions in talking about why these techniques are not
acceptable. When we talk
acceptable.
about this, we want to ensure that the charter principles are adhered to, and that we are not contributing to wrongful convictions based upon false confessions or anything of that nature, illegally obtained evidence. And as we say over and over and over, these protections are not simply for the criminals. These protections are for everybody, and this is a hallmark of a functional democratic society.
Right.
If we don't have these, as I've said before, then you're in a closed society. Yep. And you don't want to be there. You don't want to be in those closed societies where you don't really have these rights, and you kind of just disappear in the system after a 3-hour trial for something, and then you're gone. Yeah. Okay. You trust me, you don't want that. Okay. So towards the end of the interview, the appellant wrote and signed the statement regarding his involvement in the death. Parts of the statement were inculpatory, though they did not exactly correspond to the Crown's theory of the case, and that's important. Right. And during the Reed technique, so it's called the Reed method, but when you get down to the third part of it, it's the technique or whatever. The police will be feeding you information that will then lead you down a path to be making those statements to try and get you to give that corroborating evidence of your complicity in the crime. So that's how some of it will certainly align. They know how to bring you down that road. Certainly a skilled investigator.
Tricky stuff.
So 2 others were involved, allegedly involved, were charged with first-degree murder. Let me just talk about this for a moment. At the preliminary hearing of the 3 accused, the appellant contended that his statement was the product of the interrogating officer's method known as the Reed technique. He argued that the use of such a technique of interrogation should act as a material reason to find the statement was not voluntary. At the conclusion of the preliminary hearing, Justice Hawk, H-A-W-K-E, an excellent judge and who was an excellent Crown attorney, committed Mr. Liu, one of the accused, to stand trial and discharged the appellant and Mr. Dorkham. So they were discharged.
Free to go.
Having found that the statements they made to police were involuntary. So, ballsy, I'm sorry to put it that way, takes a strong judge at a preliminary inquiry on a homicide to make not only a ruling that the statement is involuntary, knowing that you're making the ruling that the statement is involuntary when it is essentially the crux of the Crown's prosecution against you, leading to a discharge, is an extremely strong, principled judge.
Yes.
Okay. So to parse that out a little bit, or to explain it a little bit better, the only evidence in the case against them was their own statement.
Basically.
And
I wouldn't say the only evidence, because we are not as knowledgeable about the prosecution case as we could if we had all of it. But it is the core. It's the core of the prosecution case. Without that confession,
Crown
for this individual, he has to be discharged at the prelim or acquitted. Okay, so at the preliminary inquiry, both the appellant and Mr. Dorkham, Dookram, I'm so sorry, DookHram, were discharged. So this was very important because her ruling essentially is similar to what the Court of Appeal determined later on. Right. Even though at trial, on a pretrial motion, it was found that the statement was admissible, leaving that aside. So after these 2 are discharged, let me just say this. The Crown decided to prefer an indictment against both of the discharged individuals. What does that mean? Crown didn't like the decision. That's right. You can go get permission from the Attorney General of Ontario to then direct an indictment, meaning you draft up an indictment directly to trial. So you recharge the individual with first-degree murder, and then they have to go to trial. You can
bypass the preliminary hearing.
No, they had a preliminary inquiry.
They already had it.
In this case, they had it. Right. They just disagreed with the decision. Right. Instead of challenge, I don't want to get into too much technicality, but the Crown can review that decision. They didn't. They decided to prefer an indictment. Okay, you can.
It's a blunt instrument. It's easier.
It's a blunt instrument. It's easier, and you can go to trial. And they did it. And sure enough, they went to trial. There was a pretrial motion with respect to the admissibility, and it was ruled admissible. Okay, go ahead.
Who's going ahead?
You.
I'm going ahead.
This is a very interesting case.
Yeah, I know. So at the trial arising from the preferred indictments, there was a voir dire, a blended voir dire, which is
A trial within a trial.
a trial within a trial, a determination about the voluntariness of the statements. Appellant, he didn't testify on the voir dire. The defense didn't call any other evidence on the voir dire, yet the trial judge still somehow ruled that the statement was voluntary and admissible. And then she released a decision or reasons for her ruling, which commented on the use of the Reed technique of interrogation.
And that's because that was raised in the voir dire, raised in the arguments, and then ultimately raised on appeal anyway. So
she also found there were no charter breaches beyond the conceded 10B charter breach. That's that initial in the car where they didn't hold off in the police car. But said there was a subsequent fresh start, and then even if there was not, the statement was admissible on a Section 24.2 charter analysis. So total opposite of Justice 𝐲𝐘𝐒, obviously.
yeah, so let's just break that down for 1 second. Yeah. So you can have a fresh start. So let's say the police f*** up with respect to asking some questions in the car. You can sort of not rely on that information, give a caution again, give the right to counsel, get the opportunity to speak with a lawyer, and then, presumably make a voluntary statement after that.
When there are decisions similar to that, where there's a statement that starts at a certain point, and they say nothing beyond before this point is admissible, but after a certain point, everything else is usable.
That can happen, and in this case, the judge said even if there was not a fresh start, it should be admitted under 24.2 of the charter, which is where I talked about this calculus that goes on in order to determine whether it should still be admitted, because in this case they could say that the judge would say that the violation was so minor and the evidence derived from that minor violation was relatively insignificant. I'm not getting into that, but you can see how what we spoke about applied in this particular case. So on appeal, one of the central features from the Criminal Lawyers Association was that the Reed technique in and of itself should result in a rebuttable presumption arising that the statement made was involuntary. According to appellant, if the amended principle was applied to the statement he made, the Crown would be unable to rebut the presumption of involuntariness. That was ultimately rejected by the Court of Appeal, and we're not going to go into that in any huge detail, but it just shows you how much tension there is around this technique and how it can lead to false confessions. You want to talk about the Reed technique a little bit, or do you want me to just keep droning on? I'll drone on for a moment.
Drone on for a bit.
I think the Reed technique is something, because we mentioned it a few times.
We should kind of get into it. So
let me just talk about this for a moment.
Okay.
So, a core part, I keep using the term core, part of this case, again, is about the common law rule that seeks to protect against false confessions. And voluntariness is a core touchstone of the rule, but this concept overlaps as well with other things such as reliability. So on the question of voluntariness, the focus is on the conduct of the police and its effect on the suspect's ability to exercise his or her free will. The confessions rule also seeks to protect the rights of the person charged without unduly limiting society's need to investigate and solve crime. This is important. In sum, the rule strives for a balance between, on the one hand, the rights of the accused to remain silent and against self-incrimination, and on the other hand, the legitimate law enforcement objective of the state relating to the investigation of a crime. The jurisprudence teaches that the rule should not be applied mechanically to the facts of a particular case. Instead, a judge must examine and evaluate all the circumstances surrounding the making of the statement. The approach is contextual. The evidence must satisfy the judge beyond a reasonable doubt that the statement or the confession was voluntary in order for it to be admissible. Sorry, I just thought, since people asked us the questions about the right to remain silent, I just thought this is important to talk about.
This Reed technique, it's pretty complex, quite honestly.
It's f***ing complex.
It's got a really interesting script that if you want to
really
do the
does.
3-part thing.
So you
I'll talk about the 9-step
you
thing
do the
later.
9, because I'll probably get tired out by the time I get
exhausting.
there. It is exhausting, but apparently it's popular and used by law enforcement still in some jurisdictions. I know what you're going to say. Okay, the Reed technique consists of a 3-phase process. So again, this is from the perspective of a detective.
Can I just say this, though?
Yes, sir.
This was developed by John Reed in the 1940s. Right. And a technique designed to evaluate the veracity of a suspect without the use of mechanical aids such as a polygraph.
Yeah.
Okay? It's just, this has been around since
Forever.
the 40s and has been worked on ever since. So it's been a project in development, but it's been used extensively in high-profile cases.
Because it gets results, but those
In the United States and Canada.
Unfortunately, those results aren't always sound.
Sometimes, yeah.
So the Reed technique consists of a 3-phase process, beginning with the fact analysis, followed by the behavior analysis interview, which is a non-accusatory interview designed to develop investigative and behavioral information, followed, when appropriate, by the Reed 9 steps of interrogation. You'll do the 9 steps in a minute. In the Reed technique, interrogation is an accusatory process in which the investigator tells the suspect that the results of the investigation clearly indicate that they did commit the crime in question. And the interrogation is the form of a monologue, so not a Q&A type format. And the demeanor of the investigator during this interrogation is understanding, patient, non-demeaning, almost like the good cop from Good Cop, Bad Cop. The Reed technique's user's goal is to make the suspect gradually more comfortable with telling the truth. This is accomplished by the investigators first imagining and then offering the suspect various psychological constructs as justification for their behavior. For example, and I guess this will kind of explain what all that just meant. For an example, an admission of guilt might be prompted by the question, did you plan this out or did it just happen on the spur of a moment? So that's called an alternative question, which is based on the implicit assumption of guilt. Right. You're giving a way out. So
that's what I was going to say when you mentioned like getting at the truth. The truth is assumed to be guilt.
Right.
In this technique.
So take us through the 9 steps.
Actually, before we do that, I just find the behavioral component really interesting. Okay. Just because when I was in undergrad, I had a fascination with psychology, and I still do. But so. Sorry, I just need
segue.
It's just interesting.
Footnote.
So the first 2 stages of the Reed method have been the subject of much psychological study and literature. And one interesting article which is outlined here in the appeal is Nadia Klein in Forensic Psychology and the Reed Technique of Interrogation: How innocent can be psychologically coerced into confession. So the first stage of the technique is a factual analysis of the particular case. So the police are doing this. Before any interviews or interrogations take place, an investigator, of course, should become thoroughly familiar with the known facts and circumstances of the case, as it would not be possible to conduct an effective interview or interrogation without this knowledge. Duh. Yeah. The interesting part. The second stage is the behavioral analysis interview and is the result of the Reed and Frank Inbau's considerable work on conducting polygraph interviews. In his work, Reed observed, and I think polygraph is just junk science. Totally. In his work, Reed observed that truthful suspects appeared to display different attitudes and behaviors during their polygraph examinations than deceptive suspects. Reed meticulously documented these behaviors over several years and developed categories of behavior symptoms that seemed to be a reliable indicator of truth or deception. This led to the creation of the behavior-provoking questions that an innocent suspect tended to answer differently from a guilty suspect. These questions became the foundation of the BAI, which is the Behavioral Analysis Interview. Using the guidelines outlined by Reed, by the end of the BAI, the investigator should be definitively or reasonably certain as to the guilt of the accused. For those suspects that are deemed truthful, this is where the process ends. For those who are found to be deceptive, the investigator moves into the final stage of the interrogation where you'll go into. I just find this fascinating.
It is. It's very cool.
Based upon these answers, which are not necessarily directly related to the case itself, these are supposed to be psychological indicators of either a guilty person or an innocent person. And based on that, then there will be a determination as to whether to go on to the third. I just want to say this. There has been significant studies done which calls into question the assertion that the interrogators can accurately identify those who are lying during a BAI phase of the interview. And I've read some of these in the past, and there is very compelling literature out there in case you're interested on this. This case will give the citation. It notes a number of these studies, and they're worth reading because if you're interested in this, I just think it's quite fascinating. I think it is a poignant piece of argument that an ability of an interrogator to accurately determine or identify those who are telling the truth or not is very difficult. And there may be many reasons why an individual may answer questions in a certain way that could lead one to conclude that they're guilty when they're not.
Suitable for use with toddlers. So like you laid
out, going into this, 9-phase, interrogation, this is what takes place after they already determined they believe the person to be guilty.
Yeah, the BAI is done.
Right.
And their goal is to get the confession now because they're convinced the person is guilty.
But let me just say one thing. I find it to be a fallacy to think that an interrogator will go into an interview thinking the person's innocent, okay? So we've seen in sexual assault cases, time in and time out, they start from a presumption of guilt.
Right.
They've said that very clearly. And, unless the accused can prove otherwise, like having a video, you'll remember one of those cases we talked about.
Right.
I think it's a fallacy that they really go into these interviews, with the exception of some rare cases, where they think somebody's innocent. Now, there have been some interviews that over my 32 years, I've seen an officer during the course of the interview change their mind. And it's rare. Don't think because I'm saying this, you should f***ing give a statement, okay? Don't.
Please don't.
But my advice remains the same. But I have seen instances where a police officer tweaked into certain things the accused was saying and started to go, oh, okay, tell me more. And then you saw how it changed, and that interview then became exculpatory, where the officer at the end of the day still wound up charging, but then actually said, I don't think he's guilty, and started to do other investigation. That does happen. But I think it's a fallacy to think that they go in it. There's been a lot of tunnel vision, but I don't even liken this with tunnel vision. This is where they go in with the specific objective. We've arrested somebody based on reasonable grounds. We know they're likely responsible for this. Let's get that confession.
Right. And so these steps that I'm going to outline, it's just really intriguing in terms of how they were constructed and thinking about how that psychologically can be effective.
We're psychological junkies here to some extent.
Truly are.
Yeah. But that said, not all of these steps would violate your rights. So
no.
There's a common things like there's some things like suggesting to somebody that this is their only opportunity to speak. Those things are not permissible. To make somebody think that this is their one chance, because of course they would have a trial where they could speak.
Right.
So there's some things like that have been determined to be inappropriate and violating. So these steps are interesting just psychologically. So the first thing is...
Because that would be an inducement.
Yeah.
Right. So those are things we spoke about before.
Yeah, threats and abusive treatment and stuff like that.
Promises.
Promises. So step one in the read technique, once you've decided this person, you want to get the confession because you're convinced they're guilty, start with the positive confrontation. You tell them, hey, look, we already know you've done it. We've got all the facts. We've got all the evidence, right? Mm-hmm. So, I'm talking to you as just to give you an opportunity, to say what you want to say, but just so you know, we already have all this evidence.
We know you're guilty. I'm giving you the opportunity to just tell us why.
I just want to, save everybody some time.
Yeah, why did you do this?
So I was like, give them the earliest opportunity to confess. Then shift the blame away from the suspect to somebody else. Saying, giving them an alternative way to justify the crime, right? So you can kind of say, well, these things don't happen in isolation. It's like, I'm sure that you have reasons and it wasn't necessarily something you wanted to do or whatever. It's like you can shift blame away a little bit.
Let me just say this. So it's to develop themes containing reasons that will psychologically justify or excuse the offense. Themes may be developed or changed to find one to which the accused is most responsive. So you may offer a number of themes to get the accused to justify their own behavior in committing the offense.
Right. Or, they also say, suggest some other persons. So they could say, you might have got sucked into it because this other person was affecting you. So you kind of give them a little bit of a moral out. Mm-hmm. And then the next step 3 is to minimize the frequency of their denials. So every time the person says, I didn't do it, and it's like, well, I know you're saying that, but you just minimize, just say, I heard what you said, but
evidence points elsewhere.
Yeah.
Or cut them off.
Step 4, the accused will often give a reason why they did not or could not have committed the crime, and then you're supposed to use that information they give you to try and move forwards to say, well, no, I hear what you're saying, but the reality is this, right? So
Why
you're kind of
don't you just
acknowledging
fess
their
up?
denials,
Yeah.
but saying, I tell what you're saying is like, really where we're going is this. And, it's an interesting set of, and these are steps, actual steps.
These have
that they
been
go
designed over, just short of 100 years, okay? It's 2025 now, so over 85 years.
Step 5 is to reinforce sincerity to ensure the suspect is receptive. So then you're just like,
Good
you
guy.
say, I'm a good guy, and I understand that, everybody does things or whatever. It's like, but you make yourself more amenable, more friendly towards the person at this step. And then they actually say in step 6, they predict the suspect will become quieter and listen once you do this.
Well, you can impress upon them in number 5, so if we can make this live a little bit, to talk about the seriousness of it, the impact maybe on the victim's family, and to talk about the officer's sincerity, and you can talk about things also why they may want to get it off their chest.
Right.
And then in step 6, what you're saying is the suspect then may become quieter, start to listen, and will move the theme from discussion towards offering alternatives. If the suspect cries at this point, it can infer guilt.
Right. So if you get someone crying, apparently that's proof of guilt.
Or they're just exhausted of this process. But anyways.
Yeah. And then you move to, and this is the most interesting step to me, posing the alternative question, giving 2 choices for what happened, one more socially acceptable than the other, and then the suspect is given the option to choose between those 2. So this is like, they're only given 2 choices.
Both are guilt.
Both of which result in, the
Admission
person
of guilt.
admitting guilt because they're choosing an option, and they will most likely choose the one that's less morally culpable.
Leaving aside the fact that there's, of course, another alternative to say, I didn't do it.
Right. Correct.
Right.
So there's always a third option, which is to maintain that they did not commit the crime, but if you can get them to choose the lesser of the 2 evils, then you've still got an admission. So then step 8 is to lead the suspect to repeat the admission of guilt. Once you get some sort of, saying, okay, well, maybe this thing is the thing that happened, get them to repeat it. That locks the person psychologically into what they've just said. And they can always go with, well, you already told me this, right? And try and get them to do it in front of witnesses and get corroborating evidence or information to establish the validity.
That's old days. Now we have videos and,
Right.
But one of the techniques that they still use, and they did in this case, is aside from your video and audio recording, you'll try and commit some of this to writing and get them to sign it, so you've got a firm commitment from them.
And that's the final step, is to document it by getting an admission and getting them to formally admit to guilt.
It feels like some of my kindergarten teachers use this.
You took the cookie from
Teachers,
the cookie
I'm
jar?
sure, no. Teachers and certain parents far better
Use
than
the
me
read
when I was dealing with
technique.
my kids. Use the read technique.
Where was the read technique when we needed it?
And, this is important because especially when people have been held for, like, say, 13 hours and stuff, it's like they end up getting worn down.
Of course.
And so they just be like, okay, and that was why it was the most interesting thing for me, giving 2 options of guilt. And
Right.
say you can choose
Easy
one
way
out,
out.
one out of the 2.
Yeah.
Because we know, and they're reinforcing from the very beginning, we know you did this.
Yeah.
So you either did it for this reason or for the
that.
lesser reason.
Right.
Where are we at right now? We're getting carried away with ourselves.
Hour and 4 minutes.
Holy sh! Okay, so we got to wrap
maybe
this
we're
up.
going over an hour.
Let's just say this, okay? So the Klein article argues that before an interrogation using the read technique starts, the investigators decide the suspect is guilty, and the purpose of the interrogation is to elicit a confession. Duh. Okay. However, she notes that the curators of the read technique deny that fact, and really they're just trying to get the truth. Bullshit. Several articles in criminology literature offer descriptions of each of the 9 steps. One of them, Tim Moore's piece, along with Lindsay Fitzsimmons, Just Imperiled, False Confessions, and the Read Technique. Another one, Chapman, A Recipe for Wrongful Confessions, a case study. There's a ton of interesting literature out here to read about this. It's incredibly interesting. Again, we're not saying police shouldn't be sophisticated at interviewing suspects, particularly for serious, heinous crimes. They should. But it's just an interesting, I just think it's an interesting area to study. and that there are inherent dangers because people psychologically and emotionally can be compelled to confess in these circumstances.
And I think for people who want to do their own research, if you just Google read technique and criticisms, that you could come up with a lot of really interesting
I'm sure you'll come up with these articles, but there are a ton of them. And again, this is, Justin Ordonio, Ordonio, 2025 ONCA 135. Well-written judgment, of course, Court of Appeal, but it's got great stuff in there. Thank you for listening. I'm sorry we went on for over an hour. Did we break a record on this one?
Potentially, I think.
All right,
it's a fascinating topic.
It is.
Pillow Talk. Remember to, don't forget to like, comment, subscribe, share, and thanks to you asking questions when the podcast dropped. This is why we came up with this one. So good night, everybody.
Good night.